call this meeting to order. Welcome, everyone. Pursuant to Standing Order 108-2, we are continuing our study of the retirement income security of Canadians. We have with us here two organizations, and then we have, I believe, 4 individuals as witnesses. We have the Nortel Retirees and Former Employees Protection Committee, 2 individuals with that organization. Nous avons l'Association de la Retraite.
We have the Association of Asbestos Retirees.
Independent financial analyst Diane Urquhart. We have Gladys Como. We have Pierre St. Michel. And we have Diane Blanchard. I'll ask each of you to make an opening presentation. I believe you have a maximum of 10 minutes, but if we could have a shorter time for more questions from members, that would be greatly appreciated by all members. And we will start with Mr. Sproul, please.
Thank you very much. Merci, Monsieur le Président. Je m'appelle Donald.
Thank you, Mr. Chair. My name is Donald Sproul. I'm the National Chair of the NRPC Committee representing former employees of Nortel. With me today is Bernard Neuschwander, Chair, Quebec Region of the NRPC.
Very quickly, I wanted to put a face on the 19,000 pensioners in Nortel that are going to be affected by this insolvency. Just remember that the people you see in front of here are healthy enough to come to these kind of functions. This gentleman here was healthy enough to make it to the Parliament Hill rally. But again, we're affecting 19,000 pensioners. The next chart, chart 3, please, is just some statistics to know what that 19,000 makes up. There's 11,700 people currently on pension, and of that, about 11,000 of them are receiving their health plan benefits. The average age is 73, and these are not golden and gilded pension plans. The average pension plan for people on retirement right now is $17,000. If you segregate that, the people that are union plans are getting $12,000 a year. On top of that, there are people who will be reaching retirement age. There are some people who have left the company, about 5,800 of them. New deferred pensioners coming on board. The long-term disability group will be terminated at the end of this year and become deferred pensioners. We think the majority of those and people laid off within Nortel will become deferred pensioners as well. So that's how we come up with a total of 19,000 people who will be affected from a pension point of view and about 11,000 people from a health and welfare benefit point of view. Again, the deferred people do not benefit from the health plan. Across Canada, we have about 9,000 people, over 9,000 people in Ontario, 6,000 people in Quebec, and the remaining 9% are outside of those 2 provinces. I presented to you in June of last year about the Nortel situation. Since then, I guess hopefully everybody's reading the newspaper. Nortel is liquidating under CCAA. Major assets have been sold, and the last major asset is the intellectual property. The company will probably be down to about 400 people by second quarter. Our pension claims have not been totally calculated, but certainly for the 2 registered pension plans, we're talking about $1.1 billion of deficit in those pension plans. The Canadian estate, we're far from being close to understanding what we're going to get from the Canadian estate when it is finally settled. We do know that there's no cash left in Canada, just enough to manage operations. The payout will come from global assets. They've all been put into a global lockbox, but it is far from undetermined as to how those global lockboxes will be unwound and what will come to the Canadian estate. Now, having just said that I think the whole thing is highly speculative, I'll go and put my speculation forward, and I say that I think we're going to maybe get between 10 and 30 cents on the dollar. But again, it's too early to tell. It's been a year of worry for pensioners, and there's no end in sight. I suspect we have another 2 years of going through this process before we'll find out what the final outcome is. Chart number 5. In that environment of uncertainty, we have now, and we're waiting to hear from the judge in the next couple of days, but there is a settlement agreement with Nortel Canada for existing benefits, and our health plan will come to an end at the end of December of this year. Also, our pension plan is going to be wound up as of September 30th this year, and at that time we expect a cutback of something worse than 31%, so something below the 69% level. That cutback is determined by the expected cost of converting that plan to annuities. The Nortel requirements for annuities will not fit within the Canadian marketplace, both the size and the type of annuities that we're talking about. And because of that, we expect to suffer more in terms of the annuity payout to the pension plan. Just so you are aware, we are exploring on an early stage with the Ontario government the concept of a pension orphanage where we avoid having to go to annuities and avoid some of these key wind-up charges. But the implication is that by the end of this year, the average pensioner will lose about 40% of their income, both in pension and health payments. And this will be a hardship for all and poverty for some pensioners. Chart 6, how did we get there? When I looked at other corporations and as we worked as a committee, and we believe we spent something close to 75,000 man-hours on this activity, Nortel is not an ongoing entity. We have negotiating power in terms of what GM had available to them, what Stelco and Algoma had to them in terms of cutting deals with both federal government and certainly with some of the provincial governments. The negotiating power with ongoing entities, of course, is jobs, jobs, and jobs. In the case of Nortel, there are no jobs. It's all being sold off, and what's left is the rump of the pensioners and other people affected by this. In Canada, there is no viable pension insurance scheme. There's another day set aside for that, we understand. There is a very limited Ontario scheme, the Pension Benefit Guarantee Fund, which will help Ontario pensioners or people that worked in Ontario, but we're probably talking about $310 a month in terms of what that scheme will pay out. And certainly for all of those pensioners who worked outside of Ontario, they will get nothing in terms of pension insurance. Finally, if you look across the global stage in terms of OECD countries, and again, there's another day for this, there is no priority for pension deficits in the bankruptcy courts, and we have sunk into the low of unsecured creditors. Now, very quickly, you know, the bankruptcy courts seem to be all about equals negotiating what's left of the corporation, and I maintain is that the pensioners and other employees affected by this insolvency are hardly equals among the people who are unsecured creditor class. Bondholders are extremely sophisticated people. They manage risk not only with Nortel, but they manage it across other investments, and they can actively manage risk in terms of shortened maturity dates. They were able to cross-guarantee between their bonds between Canada and the United States, and they can actually go out and purchase default insurance called credit default swaps. The suppliers equally have risk distributed across many customers. In some of the cases, they had negotiating power as the assets were sold off because they were critical to the business, and some suppliers managed to get 100% on the dollar. The UK government, as you're probably aware, is making noises about trying to make claims on the Canadian and the US estate. They did not get leave to make those claims, but they're going to be coming back. And the UK Pension Administrator, back in 2006, negotiated a deal with Nortel Canada, with the parent company, to cross-guarantee some of the pension obligations for the pension administrator in the UK. So finally, pensioners, we never contemplated company default. All of our risk is concentrated in a single entity, and it's just concentrated in Nortel Canada. It is not spread across all of the Nortel entities. So pensioners, when they took a pension, did so to avoid personal risk. Would they live too long and not have enough money? Would they live too short and their wife not be taken care of? And would they become sick? So I maintain and hear that pensioners are hardly among equals when it comes to being unsecured creditors. So finally, what is our request? We are requesting that the pensioner claims are preferred creditor, be given preferred creditor status under the bankruptcy laws. We would certainly rank below multiple classes of secured creditors, and hopefully that would not impact the ability of corporations to restructure. But we do wish to be at the rank at the front of line of unsecured creditors. And our pensioner claims would include pension deficit and health and other claims. Now, when making a decision and trying to understand the impacts of what that means within the bankruptcy environment, we do ask you to weigh the societal and costs. And my colleague to my right has actually calculated that at being in the order of $355 million. She's also done work in terms of what does it mean, because people say there's going to be increased capital cost in terms of bankruptcy laws, changing the bankruptcy laws. And her estimation has for corporations, for all corporations, an increase of 0.02% to 0.11% for all corporations, and for those Corporations who are in pension deficit, her estimate is 0.16 to 0.79%. So yes, there will be a cost of capital increase, but let's think about what it means to the societal cost. I would also maintain, as I went through these charts, I began to think about what happens if corporations actually had to pay that amount, and it actually might make them top up their pension plans to the level and not get into the situations that they're in right now. I will turn it over from a summary point of view to my colleague, Monsieur Nishwanda.
Merci, Don.
Thank you, Don. To conclude, we believe it's high time to amend bankruptcy legislation, a legislation that we believe do not meet the needs of today. Government is granting more and more time to insolvent companies to ensure solvency. There are no measures provided to protect retirees in the case of the bankruptcy of their former employers. That is simply unfair. We are playing with the money of retirees without providing any measures to protect them when companies go bankrupt. Canada is a country that is recognized for the quality of its social programs and the only country of the G20 not to provide any protection to retirees in case of bankruptcy, either in the form of a pension plan scheme as we have in assurance fund in the United States or the UK, or to give a higher priority to pensioners in case of bankruptcy. Such measures, we are told, that will increase capital costs and have a dampening effect on competitiveness of our corporations. But the studies that we have show that the increases would be minimal and that they would only affect companies that are already facing difficulties. As such, pension plans are, in our views, liabilities just as other liabilities of corporations. Pension plans are not gifts given by employers to their former employees. We are also aware that the government is considering reforming the retirement system and consultations are underway. We understand that, given that context, that we don't want to do a piecemeal revision of the system. Our demands sit well as part of a comprehensive review of the system. To change bankruptcy legislation does not compromise the pension plan system. Our retirees and retirees from other insolvent companies don't have time to wait. On September 30th, our plan will be liquidated with devastating effects for a number of us. The changes that we are calling for would offer adequate protection to our retirees without costing an extra penny to Canadian taxpayers. And I think it's important to point that out, without costing an extra penny to Canadian taxpayers. And Don has indicated that we could even have savings of $350 million. This is certainly an offer you can't refuse. Our 19,000 retirees and former employees are counting on your support. Thank you for having heard us today, and we will remain here to answer any questions you might have. Thank you for your presentation. Mr. Fréchette, please. Good afternoon, Mr. Chair. My name is Gaston Fréchette. I am here with Mr. René Langlois, Secretary of our committee. First of all, I would like to thank you all for having invited us here. That's proof that there are problems with pension plans. If you take the time to invite all these witnesses, it's because you want to hear what we have to say about these problems. I want to talk to you about 1,300 miners in the asbestos mines who have spent their lives in the asbestos mining industry. And on October 25th, 2002, overnight, we heard from the president of the mine that big pensions were a thing of the past. Insurance was a thing of the past. Everything was a thing of the past. We learned that our pensions would be cut by at least 20-25%. And we also learned that pension cuts would go from 35 to 40% actually. That is to say, an income loss in asbestos of $5.5 million a year per year. You also have to know that asbestos, for those who have already been there, is a small town. It's almost a village. Today, it's down to a village. The only employer there, actually, the only employer the village had was the mine. There were 1,300 employees. Those workers worked over 3 shifts. So the time the spouses could work outside of the shifts, actually 95% of our people, there is one person in the family working, usually the father of the family. All this to say that when we had our pensions cut, there was one cut for the 2 parents. The only thing that they could receive was old age security. So if you calculate all that, this amounted to significant losses for families. And when we were faced with this, we took steps, we formed a committee, we did what we could. And we went to Quebec City in 2003, and we went to see the Premier and received $4.3 million in assistance, which represented 11 months of loss income. And we met Christian Paradis, who was the minister and who knows our situation very well, and he isn't afraid of asbestos. And we also met your former minister, the member for Beauce there, Maxime Bernier. I don't want to make any funny jokes, but I'm wondering whether he forgot our documents someplace. No, it's not a funny joke, I understand. But we gave him a bunch of documents, nevertheless. But we did receive notices from yourselves. We sent you letters. We received responses. Which brings me to the same problem faced by people at Nortel. The legislation on the CCAA. That legislation needs to be changed. That legislation made us lose at least $20 million because the banks, the credit unions, the Caisse de dépôt, which got the money, and we were treated as if we were Pepsi retailers. We receive $1,000 each. So each and every one of us lost at least $100,000. Each and every worker at the mine lost at least $100,000. The average age of retirees is 75. We talked about Mr. Bellavance's bill C-290. People would think that that might cost too much, but if the CCAA could at least put employees on the same level as secured creditors, then our losses would have been minimal. And now people will tell me, well, if things are done that way, companies won't be able to get loans as easily. The only thing that companies could do is not to promise pensions that they can't deliver on. They should have 100% a solvency ratio. But since 1991, the Jeffrey mine never had a 100% solvency ratio. And I can prove that with the documents I have. You must realize that the retirees are the big losers here. I would like you to put yourselves in the position of those retirees. If Quebec teachers lose 35% of their pension, we wouldn't hear anything else in Quebec. That would be the only thing we'd hear in the media. The only thing we want is things that we lost and that we believe we are entitled to receive. We are entitled to receive those pensions because we worked hard, we succeeded, and we actually. Why are we the only creditors who cannot deduct losses from all those, deduct those losses? How come we can't deduct those losses? don't forget, you are the lawmakers. If you called us here today, it's to try to improve those laws, and we appreciate that. And we do hope that we can live in Canada with dignity. I would like to say that we're ready to answer any questions you might have. I don't want to take up too much time. We're not here. We're here because we're 73, 74 years old. We've been working on this for the past 8 years. We've just won a friendly settlement. We earned $7.5 million in a friendly settlement, and we got the court decision on Thursday. So we've been working hard, and we're here today to say thank you for listening to us, and we're available at any time if you need us, and we do hope that we'll see the end of this before we're 6 feet under. Thank you very much.
Please.
Good afternoon. Canada lags the world in protection of its terminated employees, pensioners, survivors, and long-term disabled employees during bankruptcy. I did a study over the Christmas-New Year season and found that 40 of 53 countries studied by the OECD have preferred or better status for employee benefits, or they have a public pension benefit guarantee insurance program. The impact of preferred status for employee benefits on the cost of credit is nominal. Despite several efforts to find research reports from the investment community, no research studies have been produced to demonstrate otherwise. Corporations that liquidate with cash on their balance sheets should not be permitted to shift their employee benefit costs onto the public purse, as this places a burden on all taxpayers. The Social Security programs must be preserved for Canadians that are most in need, for the Canadians who did not work for large employers who offered employee benefits. The unregulated credit default swap market and the proliferation of private equity leveraged acquisitions have made bankruptcies a for-profit business. These two new forces in the economy encourage business liquidations rather than restructurings as ongoing concerns. The distressed debt buyers, the credit default swap hedge junk bond owners, the executives, and the bankruptcy professionals are generally making profit from the liquidations. It is questionable whether the liquidations are protecting jobs in Canada. Government must ensure that the economy is functioning on sound drivers and that business is conducted in a fair manner. Society expects government to intervene when unfair business practices take advantage of the Canadians who are unemployed, who are senior, who are survivors, who are the long-term disabled. I support the federal bankruptcy law amendments to give preferred status for pension fund deficits and unpaid severance ahead of the unsecured creditors. In addition, I strongly recommend that the long-term disabled receive distinct protection in Canada's bankruptcy laws. The long-term disabled must be given priority over other creditor groups, including other employee groups. My level of concern about the long-term disabled employees getting priority over other employee groups has risen in recent months. I have learned that there is limited to no funding within current health and welfare trusts to pay for the long-term disabled wage loss replacement income. Millions of Canadians who work for private sector employers think that they have secure long-term disability benefits when they do not. In my review of Nortel, I was surprised to learn recently that there is over $100 million missing in the Nortel Health and Welfare Trust. This is causing a funding ratio for the wage loss replacement income and the essential medicines of the disabled at only 17%. There is an alleged breach of trust since Nortel failed to make employer contributions into the Health and Welfare Trust for the long-term disability benefits plan for many years. In addition, Nortel borrowed $37 million from the disabled money and from the survivors' money that was held in the Health and Welfare Trust. Both abuses are in contravention of the trustee agreement. The group most deeply affected by the missing money in the Health and Welfare Trust are the disabled. As a consequence, we have 400 Nortel long-term disabled employees who are being needlessly driven into poverty. A single disabled person who once worked for $70,000 is now expected to have an effective income after medical costs of under $16,700. This is below the poverty line. This would be typical of all of the 400 long-term disabled. Meanwhile, in the bankruptcy estate of Nortel, there is $6 billion of cash for disbursement to creditors throughout the world. How is it possible that $100 million missing and a $37 million loan wasn't put back into the trust for the benefit of the survivors and for the disabled before the company entered bankruptcy protection? It is unfair for the long-term disabled to be put into poverty while the executives are receiving retention bonuses and while the annual incentive payments together total close to $500 million. The disabled are not treated equally, both from a Social Security pension perspective in Canada and from the regulation of the Health and Welfare Trusts. Disabled pensions are much lower and less secure than retiree pensions from both the government and the employer sources. You would know that the Canada Pension Plan disability income for a single person is a maximum of $13,521. The combination of the Canada Pension Plan and the Old Age Security is at $17,400. On March the 11th, Canada signed the United Nations Convention on the Rights for Persons with Disabilities. Under the UN Convention, the federal government must ensure that within its sphere of responsibility that it promotes equality for persons with disabilities. We clearly have much to repair in terms of the equal treatment of the disabled in bankruptcy law, within the CPP disability, and in the combination of both the employer pension and the CPP government pension. Most disabled persons are young. They are not able to accumulate personal savings for their retirement. So this is a group who will not retire well. Their pension accruals through age 65 are also very, very low. I want to make a brief point that the Canadian Bankruptcy Court procedures are not protecting the disability income from disability pensions from abuses in the Health and Welfare Trust throughout Canada. It is not just Nortel. It is other very large and reputable companies who are operating their affairs on the basis of self-insured disability and medical benefits without funding within the Health and Welfare Trust. We are seeing settlement offers of duress imposed on the disabled. The disabled face threats that their medicines could be withdrawn within 8 weeks if they do not accept the offer that is put before them. There is not special care taken in the bankruptcy reports, in the courts rather, in order to ensure that settlement offers given to the disabled relating to their wage loss replacement and whether or not they will live in poverty for the rest of their life, that they get the information that is sufficiently clear and provided to them with an adequate accommodation of time so that the disabled, their guardians, and their second opinion legal counsel can make informed decisions. The disabled will always be a minority creditor group. That's the nature of being disabled. It could be any one of us struck with disability next week, next year, in the next 20 years. And once disabled, you are a minority in the country. It's very, very important that the bankruptcy proceedings are able to give distinct protection and to priority over other employee groups due to their vulnerability of illness. This is enough to give them distinct protection because they need the peace of mind in order to have quality of life. In conclusion, I urge the federal government to play its role of ensuring the economy is functioning on sound drivers and that business is conducted in a fair manner. The unfair business practices that have been enabled by the credit default swaps and by private equity leveraged acquisitions and our archaic bankruptcy laws cannot be permitted to take advantage of Canadian taxpayers, the unemployed, seniors, and as I have said today, the most vulnerable amongst us, the disabled.
Thank you very much, Ms. Urquhart. We'll now go to Madame Como, please.
Bonjour, good afternoon. Mr. Chairman, honourable members of the committee, Madame et Monsieur. Merci pour votre invitation de comparer.
Thank you for inviting me to appear before your committee.
Canadians, I like that. I sincerely hope I can make today a positive contribution to your efforts. I am Gladys Como, née Murray, born in Alberta, and also I lived in BC. Living now in Quebec, widowed 15 years, surviving spouse of Gilbert Como. Gilbert worked 41 years for Northern Electric, Northern Telecom, Nortel. He was a compassionate, hard-working husband, father, and always looked forward to his due pension. I repeat, due pension. He opted for a reduced pension to ensure that I would be financially protected with the survivor's pension. I can still picture him during his last 4 months of life when we knew the inevitable. He worried if I would be able to make out in spite of the survivor pension that he had made provision for, never thinking that Nortel would default from their promise and enter into bankruptcy. We both worked. Not as long, of course, as Gilbert. We reached middle class. Not today. I'm at the bottom of middle class. 2009, I received notice, appointed monitor of Nortel's intended bankruptcy, that my survivor's pension would be impacted. Immediately, on my own, I requested my federal MP, Madame Marlene Jennings, provincial MNA, Mr. François Mimet, to provide documentation on the government's stand on the effects of bankruptcy on company-sponsored pension. Also, I have only been a recent resident of Lachine. I was many years in Chateauguay. I also contacted Madame Carol Freeman, the MP of Chateauguay. These people were there for me, and they still are. The legal implications were not familiar to me, but I soon learned that I would be entering into near poverty if the government did not change the acts to protect all Canadians. I am 75 years old, receiving minimum old age pension, Rentrée Québec, and Nortel survivor pension, which survivor pension keeps me above poverty. Please believe me, this is the truth. I live in a mortgaged one-bedroom condo, no car, lead a modest life, which includes many hours of volunteer community work. I feel fortunate to have this survivor pension. It means I'm not a burden on society, nor my children. As a direct consequence of Nortel's bankruptcy, my survivor pension will be reduced by over 30% this September 30th. 6 months. Who can do something in 6 months for us? The future looks grim. I have to agree with Mr. Sproul. Mr. Sproul, Diane Urquhart, amendments must be made to the Bankruptcy Insolvency Act, other acts pertaining to business. This, to me, at this time, is unjust and bordering on criminal. September the 30th, let me repeat that. If this government continues to abandon us by not changing the acts to protect people such as myself, I will have roughly $200 less a month in my hand. That's not much for some people, but that's the difference that makes ends meet for me. Now permit me to address the loss of medical benefits. This issue must not be taken lightly. I am fortunate enough to have no major medical problems, not at this time. Therefore, I am not counted among the many pensioners with debilitating medical conditions, very expensive. I am not to say how long I will live, in what state of health. I could buy private medical insurance later, No, not with the cost, and I will not do so. The anger, the anxiety, depression, I thought these were my words. They've already been used today. Many of us are experiencing will lead to serious medical problems, and you can be sure these problems will occur in the not-too-distant future. I stand before you today, as others have done many times over and over through the year 2009, requesting enactment of legislation. I won't go into more than that. But I still say that the deferred wages, Nortel, actually belong to us. And I repeat what I wrote many times in my correspondence. If there's anyone here who has not received correspondence, I'll be very surprised for me. Please do not be influenced by anyone opposing our demand for justice through tactics of persuasion. And yes, I am afraid. I'm a taxpayer. I look towards my government to protect me. I received Mr. Flaherty's letter, signed by Mr. Flaherty's letter, just a couple of days ago, and his words were, the government's responsibility. As I lost my envelope, I don't have it with me, but those were his words. And then he mentioned I did the right thing to send to Mr. Clement, who I have never heard from. I am open to your questions and comments. Merci de votre attention.
Thank you for your attention, honorable members of the committee. I'm ready to answer any questions you might have. And in conclusion, this is for you, Gilbert. Thank you. Thank you for your presentation. And finally, we'll hear from Ms. Blanchard and Mr. Saint-Michel. Mr. Chair, committee members, ladies and gentlemen, good afternoon, and thank you for listening to us. My name is Diane Contant-Blanchard, and as secretary for the group of retirees of Atlas Steel that I appear before you. Our group was founded on June 14, 2005. Its mandate is to call for fairness to which all Canadians aspire to, who during their active lives have agreed to make sacrifices to live out their golden years in dignity. I joined Atlas Steel in 1966 and left in 1997, proud of having met my commitments and having loyally served the company for 31 years. Having contributed to the pension plan during all those years, and thanks to the collective bargaining agreement, I receive a plan which was agreed to upon my leaving to the end of my days. And the pension plan amount is indexed annually. But since October 2004, the wind has turned. More than 7 years after my departure, I learned, just like my 275 retiree colleagues, that in the future, our pension income would be cut by 30%, and in some cases would only reach 58% replacement income. We could never have imagined such a tragedy. It was a general surprise. We were astounded. It had the effect of a bomb. I had never been advised that this could happen. I was never asked to speak about a decision that could have such an impact on my future and quality of life. How can they cut the pension income when it was supposed to be guaranteed? How can it be cut when Section 6 of the CPP Act establishes that the pension plan is a heritage trust and the interest of participants must be prioritized? How can these pension incomes be cut when Aon Consultancy Group, through its actuaries and investment policies, must make sure that our pension plan is covered? How can we be cut when the regime solvency rate was 120% in 1999? And yet, since July 1st, 2005, up to $900 were cut from our pension income, which represents a significant gap. For close to 58 months now, the life of Freedom 55 with its sandy beaches and golf courses, which is a dream of workers, is that but a dream for Atlas Steel retirees who have to meet challenges, the financial challenges, harsh financial challenges. Every time we open a bill, we see increased rates. And with such cuts in our pension income and no indexation for almost 5 years, poverty is now reaching a critical level. How can a couple with a single pension income from Atlas survive? We have to limit our everyday expenses, our food, housing, Medicare, and gas expenses. How can a couple living in a foster home make ends meet? We have to make do with mediocre quality food and services. The Harper government implemented a home renovation tax credit program last year. Did we benefit from it? Absolutely not. You had to spend $10,000 before being able to see any money come back to you. That is about the money that we receive a year. So any additional spending creates unease. This situation has a number of negative impacts. We have to move to a more modest housing, sell our properties before we wanted to, reduce our food consumption, have to make do with less clothes, less holidays, and travels. This missing 30% is what made our lives supportable. Psychologically speaking, we've seen reduced quality of life, and elderly people are being prematurely affected. And among my colleagues, 23 have already died. There's a $2 million loss and that money is not going back into the economy. We can no longer pay taxes as we did in the past because all our money goes into meeting our housing and health needs. Let's talk about the RRSP programs, a program implemented by the government to encourage savings for the retirement age. I believe that we have once again been mistreated with these programs. Canadian retirees are among the happiest in the world, is what I read in the papers. Retirement is a happy time where people can enjoy their pastimes. Or I read the following: the older you get, the more fun you have. But why isn't that the case for retirees of Atlas Steel? Because their dreams have been stolen. And yet, we've worked hard for 30 to 40 years. And during those years, we contributed to our pension plan. We trusted all these institutions and pieces of legislation that are supposed to protect former workers and to defend their rights. We participated in our society through the payment of taxes, and despite our advanced age, we are still contributing to the prosperity of our country through our volunteer work and the help given to our relatives. Retirees recognize that the situation is different for public or quasi-public former workers. Is working in the private sector, should we be punished for working in the private sector? Ladies and gentlemen, committee members, thank you for having allowed us to raise your awareness to our difficult conditions. You who have the power, allow us to end our days with dignity. Thank you. You have 2 minutes. Well, I believe our Secretary, Ms. Blanchard, summed up our situation. However, I had some things I wanted to add. I simply want to point out that it is close to 5 years that we've been living this social injustice. For us, it's inconceivable. And I would like to say that during the past 30 or 40 years, during which we worked for Atlas Steel, we were told that part of your salaries are being deducted. But when you will retire, you will have a pension income. It's guaranteed. They lied to us. And not only did they lie to us, but they stole from us. And if they were able to do that, it's because the current legislation is too complacent. And so we, too, agreed to say that the laws have to be changed. And in cases of bankruptcy and insolvency, pension plans should be prioritized. I would also like to say in the case of Atlas retirees, no lawsuits are possible. The company has liquidated all its funds. Secured creditors went away with all the money, and we are left with our cut pensions, cut between 30 and 58%. 58% of our pension income cut. That's a lot. And that has had a major impact on our lives. Now, I don't want to be too dramatic, but every time I go to a funeral and a retiree passes away, there are relatives who speak to me about this, and they say that the cuts to the pension income sped up their passing. And I believe that, because when you worked all your life and you come to the end of your life and you see such things happening, it's not easy to experience. There's an 83-year-old man who told me, and I would like to share this with you. He told me, a society is judged by the way it treats its older people. And in my case, I feel we treated us as a past, we were just discarded by society, simply said. And that I'd like to thank you for letting listen to us. Thank you, sir. We will begin with Mr. McCallum for 7 minutes.
And I'd like to share my time with my colleague, John McKay. And first of all, I'd like to thank all of the witnesses for being with us today, and particularly those describing their own particular very difficult situation. Je remercie tous les témoins.
We'd like to thank all witnesses for coming before us this afternoon. And I do thank you for what you have told us concerning your circumstances.
Virtually all of you are concerned with issues surrounding the Bankruptcy and Insolvency Act. I'd like to begin with a couple of words on that, plus the situation of the long-term disabled, and then ask a question or two. We in the Liberal Party, or let me put it this way, Judy Scrow, who is the pension critic for the Liberals, and myself as finance critic, will be recommending that Liberal Party support the NDP private members' bill on amendments to the BIA as and when it comes to the House of Commons. We don't know when it will, but as and when it does, we will recommend Liberal support for that. In addition, just today, I think this afternoon, Senator Art Eggleton presented a bill in the Senate which would give higher status to those on long-term disability. And in the Nortel case and also in other cases would guarantee that those individuals receive the money and the medical treatment to which they are entitled. And we are hoping, we don't know yet, but we are hoping, given the catastrophic situation facing these individuals, should this bill not pass, we are hoping that this bill in the Senate might command all-party support. But it's too early to know the answer to that yet. So I'd like to ask Mr. Sproul a question. just today in the House of Commons, Finance Minister Jim Flaherty was asked about amendments to the Bankruptcy and Insolvency Act, and he said the following: as was stated in the speech from the throne, work is being done on that issue. It is an important issue for Canadians, and we have to try to move forward on that issue. But on the broader pension issue, again, I say to the member opposite, we have one of the best pension systems in the world, blah, blah, blah. That part is not important. The part that is important is, well, that part is certainly questionable. The specific point I want to address is Mr. Flaherty's statement that work is underway by the Conservative government to amend the Bankruptcy and Insolvency Act. And since you and your group, Mr. Sproul, are at the center of this issue right now with the Nortel people, my question to you is whether Mr. Flaherty or Mr. Clement or any other member of the government has approached, since the tabling of the budget, either you or a member of your group to advance the cause on amendments to the Bankruptcy and Insolvency Act?
The answer is no, they have not.
Well, perhaps you're the most likely. Has any other member of this group been approached by any member of the government on potential amendments? Well, or as Ted Menzies approached you, Mr. Sproul, he's the parliamentary secretary. Has anybody in the government approached you on the amendments that were promised in the speech from the throne to the Bankruptcy and Insolvency Act?
Since the speech from the throne and the budget, no, we have not been approached.
Okay, well, thank you very much. And I'll turn over now to my colleague John McKay. Merci beaucoup.
Thank you. A lot of this conversation seems to revolve around the prioritization on a bankruptcy, and you say in your material that it wouldn't have any significant impact on capital. I think both Ms. Arcard and Mr. Sproul said the same thing, and it's counterintuitive. I mean, accepting for the moment the proposition that there should be a priority or a super priority attributed to situations such as yours, it would seem to me that it would have an impact on the raising of capital, and that somehow or another the raising of capital would morph in some manner or another to regain the priority. So I'd be interested in your observations with respect to A, what precedents are out there, and B, how you would get this super priority, which would in fact be a super priority over the long term.
I'll hand it over to Diane, but we're certainly super priority, from what I understand, is the top of the pecking order above secureds, and that's what's been given in the case of the WIPA legislation. Our request was very specific, is to fit below secureds, but above the unsecureds, at the head of the front of the line for unsecureds. So again, you need a company's ability to restructure and to get DIP financing, etc. But we wanted to be at the front of the line of the unsecureds. And I'll hand it over to Diane.
Okay, John, I'll answer the first question first, and that is, intuitively, you think it must have a material impact on the cost of capital. For me, intuitively, it's the opposite. In the investment grade markets, over any 10-year rolling period in the last century, only 4% of investment grade corporations become bankrupt. In the junk bond market, 26% become bankrupt. And so the cost of capital and any change in the bankruptcy law relates only to that small percentage of companies who indeed go bankrupt. And so by the time you take that into account for all of the corporations as a whole, then the cost of capital is de minimis. In the work that I have done with the investment grade, it's 0.16% would be the average based on the Moody's statistics for bankruptcy and the losses that are borne by bondholders in the bankruptcies of the century.
Nortel or Atlas or any of the companies represented here, investment grade? Very briefly.
Well, Nortel is junk bond. Atlas.
No, it is now. But what was it when the investments were made?
Nortel has been junk bond since 2002. And so all of those who presently own the Nortel bonds would not be investment-grade owners. They were long gone at the end of the tech wreck.
Okay.
And so, so therefore, in terms of the cost of capital, there's no question if you have a car accident and there's damages to the car, there are damages to the car. But there's only a certain percentage of society that gets into car accidents. And so this is the phenomenon we're dealing with.
Thank you. Trying to get all time for all members here. Thank you, Mr. McKay. Monsieur Paet, s'il vous plaît.
Oui, merci.
Thank you for your testimonies. We sometimes say that the capitalist system is the less worse system, and we see the worst of its effects. And these are some of the most touching testimonies that we've heard. I would like to say a few comments. Someone said that the pension system was like an insurance system or insurance plan, and to ensure pension income. No, it's simply a salary. It's a wage that part of your wage was deducted, and together with contributions from the employer, and not contributing anything and having contribution holidays, it's as if your salaries weren't paid. So the whole issue of solvency, requiring a corporation to resume contributions and also to require a corporation no longer to contribute when the solvency ratio is over 120 doesn't make sense. I think we should go further. We should say, yes, if there's a solvency ratio above 120%, well, why not? And the 110 or 120 debate is, well, all that was to avoid a tax loophole. And I think a tax problem was to be resolved, but at the same time a black hole was created, and you're sitting in it. And I think your demands are quite justified, but I think we should further. No longer contributing is basically what the government does sometimes when it dips into the EI fund. It's about the same kind of theft. The second element, with regard to what you said concerning bankruptcy situations, the revenue agency, unpaid wages are usually paid from the outset. So given that logic, for secured creditors, we should make sure that retirees, pensioners, receive these wages that were unpaid, and they should have the same priority as salaries who've been there in the past couple of weeks and go and have a higher priority. And so this is my last comment before I ask a question. With regard to funding, and I agree with Ms. Urquhart, I myself was a financier and economist, and their job is to assess risk. Of course, a company that is near being insolvent will not find any financing in any case, and a company like Nortel, when the stock was at 1,000, the equivalent of 1,200, and today it's worth nothing. I'm sure that all bankers in the world would have lent them money without any additional interest because of the pension plan. Now, given that logic, that we could be secured creditors, I think that would call on financiers and shareholders to better look at the whole pension regime and ensure better provisions and a better cushion to ensure that you're better protected. What I do hope is that you're calling on us. We are not part of the government. The only people representing the government here is the Parliamentary Secretary to the Minister of Finance. But I do hope this will lead him to put pressure and to stop talking about consultations, tours, and analyses. I think your demands are clear, And I'm looking at page 9, your conclusion, where you say that the amendments will have a minimal effect or have no effect on taxpayers. I think that's what we have to keep in mind. Now, so my question to Ms. Fréchette, Mr. Langlois, Mr. Saint-Michel. Now, the other programs, for instance, Medicare, and the other benefit programs, what happened to them? We lost $55 million in income, pension income, as well as health care benefits. We lost $100 million in total. And so those cuts were not 20% or 30%. No, all benefits were cut 100% across the board. That's important to say. And with Atlas Steel, well, the same story. We have no longer anything in terms of benefits, no more group insurance. We had a death entitlements, and we received no longer anything. I would like to come back to the Jeffries mine. The infrastructure equipment was modernized, and you still produce excellent product. But many retirees there at the start of their career well, we were all affected in terms of health care benefits. When our pension fund was shut down, Desjardins bought back the pension fund, and that's where we came to a 38% calculation. They had difficulties giving us that, because so just to say that we hear a lot about asbestos, and people say it's quite dangerous, but my person isn't affected. My psyche is. Last question to Ms. Urquhart. I apologize if I don't pronounce your name correctly. One of the solutions, if one of the solutions had been that when an insolvent company's pension plan, like in Quebec, the Régie des Rentes, took over those insolvent funds in order to manage them. Do you believe that in the rest of Canada, like the CPP could do the same thing as the Régie des Rentes?
I would like to see the BIA amended so that the bondholders at the time of the liquidation make up for the deficit that's in the pension plan and the long-term disability plan. The extension of the plan puts all the risk onto the shoulders of employees. And given the volatility in the stock market and even in the credit markets that we've seen in the last financial crisis, I believe that's a burden that's placed too high on the shoulders of the employees. I could imagine that it would be possible to have a compromise, in which case the estate would provide money up front, and then if in 5 years there is a surplus and that the capital markets do recover, then we could give the money back to the bondholders at that. But they would bear the risk, or some sharing formula would occur over the 5-year period.
Okay, thank you. Merci. We'll go to Mr. Hebert, please.
Thank you, Mr. Chair, and thank you all for being here today. Certainly very much enjoyed the information that you've provided, and for those of you that are facing very difficult circumstances, it was very informative to hear what you had to say about what you're facing. I have a couple of questions. The first one being for Mr. Sproul. In your report on page 9, you mentioned an independent study that showed the impact on the cost of capital. I was just wondering if you could provide that to the members of the committee at some point. Are you referring to Madam Urquhart?
Madam Urquhart did it, so...
Oh, so that's your study that's referred to in this report?
That's correct, yes.
Okay. Do we have a copy of that, Mr. Chair, of that report?
Which study is this?
The independent study that was done by Ms. Urquhart.
Have you submitted that to the clerk?
I can do so.
Okay.
Appreciate that. Thank you very much. Madam Urquhart, you mentioned in a comment just a few minutes ago that the increased cost of capital was minimal. I just wanted some clarification. Were you referring to the cost for all corporations or only for those corporations with defined benefit plans?
The estimate that I have for those corporations that have pension plans and pension plans that have a deficit is that the investment grade companies would experience 0.16% increase in the cost of credit. For those that are speculative grade, junk bond rated, I'm saying that the impact is 0.79%. Rise in the interest rate that would have to be paid by a corporation who's raising money who is junk bond rated. So that is the higher cost. I'd also like to note that today there is twice as many credit default swap dollar value outstanding than there is junk bonds. And so even in the junk bond market, that's for an unhedged junk bond owner who's going to experience an increase in the cost of capital. We have hedged junk bond holders which will bear no increase in the cost of capital at all. In fact, they would like to see a bankruptcy triggered so that they can collect the insurance money and have no loss whatsoever. And so my numbers of 79 basis points for the junk bond market does not take into account that we have more than twice as many credit default swaps outstanding on junk bonds than there are junk bonds in the world.
Appreciate that. In your report, in your remarks early on, you referred to 40 of 53 countries, and then you continue saying they have preferred or better status, or they have public pension benefit guarantee insurance. Could you just elaborate on what you mean by public pension benefit guarantee insurance?
There are 12 countries of the world that have a public pension benefit guarantee insurance plan. This is a Crown agency in which corporations who have pension funds are obliged to pay premiums to the Crown agency. It is an insurance plan such that if a corporation were to become bankrupt and there's a deficit in the pension plan, then those Crown insurance organizations such as the U.S. Pension Benefit Guarantee Corporation will accept the pension fund and will continue to pay the pension income to the participants in the plan.
Up to what maximum?
In the United States, it's to a maximum of $54,000 based on the current currency. In England, it's approximately £28,000. Thank you, Don. And in Germany, there is a public insurance plan all the way up to Canadian dollar equivalent, the last time I looked at it, at 120,000 Canadian dollars per year.
Okay. A little bit later on in your comments, you mentioned that there was a breach of trust, or alleged breach of trust. And then further on, you comment about a court-appointed representative and the negotiations going on there. Is that breach of trust being litigated?
We're waiting for a Justice Morowitz decision any day. There was a court hearing on March the 3rd to the 5th in which there was a dissenting group of long-term disabled employees who, for the record, I was retained, as was Joel Rushon of Rushon Genova, to represent the dissenting employees. And the purpose of, there was an opportunity to be opposed to the settlement agreement, which would be a proper form of justice. And so that opposition was rendered and the allegation of breach of trust was made, and we're waiting for the Justice Morowitz decision as to how he wants to handle that allegation.
Okay. Mr. Chair, I have just one more question before I choose to share my time with my colleague, Mr. Genereux, if there's time left.
You've got 2 minutes. So.
Okay, then this will be brief. You talk about conflict of interest occurring between the court-appointed representative and the rights of the disabled. Could you just elaborate on what those conflicts are?
In a bankruptcy protection proceeding, which is the CCAA proceeding, a representative counsel may be appointed by the justice. That representative counsel is then directed by a steering committee. The steering committee represents persons who represent the constituency groups. In the Nortel case, Koski-Minsky was appointed to be the representative counsel for the disabled, for the pensioners, and for the terminated workers. And I think from the numbers we saw from Don's presentation, there are approximately 25,000 total persons that were represented by Koski-Minsky. There were 2 steering committees. One was for the pensioners and the terminated workers, which is chaired by Mr. Sproul, and there was a single-person steering committee for the disabled, chaired by a person whose name is Sue Kennedy. And so what happened in the negotiations, first of all, there's one rep council for all, and the two steering committees joined together for the negotiation of the settlement. And so it was the opinion of the dissenting long-term disabled, myself and Mr. Rashan, as legal counsel retained by them, that the 400 persons who were long-term disabled did not have their interests served as 400 persons, because there was no effort made to establish, basically in the settlement, there was a denial of the right to sue the parties who were involved with the Health and Welfare Trust in order to gain remedy for the $100 million that was missing from the trust. And so it was the opinion of Joe Rashan delivered to the court that there was a conflict of interest as a result of the LTD steering committee joining in the negotiation with the other 24,600 persons represented.
Okay, thank you. Thank you, Mr. Hebert. We will go now, Monsieur Mulcair, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to say straight out that I'll be sharing my time in the first round of questions with my colleague from Thunder Bay, who is a sponsor of a bill, and he'll take the second round for the NDP. I would like to begin by thanking you all for appearing today, especially Ms. Blanchard, Mr. Saint-Michel, Gladys. Thank you for putting a human face on the people from Nortel have given us a document, but you impersonate the situation. We learned yesterday that the government would again hold consultations across Canada, but I think it's clear what we have to do. The Parliamentary Secretary, Mr. Menzies, already held consultations during the last prorogation. They were supposed to recalibrate during this prorogation and be ready to act, and that's what's missing now, the willingness to act. And as you said, Gladys, there's a date looming. Things are urgent. We have to stop. Ms. Urquhart, your intervention is so useful and very helpful in our work, and you've raised something that was already raised by experts, and it's a great concern to us. There are incentives within our current legal structure to force companies to bankruptcy, which is completely astounding. I thank you for giving the comparisons with other countries to show that we're lagging. We boast of being at the forefront, socially speaking, but we're not. So thank you for that. For you, Mr. Neuschwander, I would like you to share with us your studies. You indicated earlier that according to the opinion that we received, that it would not represent additional cost to taxpayers. Could you share that with us? Well, these are the same studies that Ms. Urquhart, well, perfect then. I was glad to hear my colleague, even though he's in another political party than myself, but glad to hear him, John McCallum, say earlier that the Liberals would support our bill. I was very glad to hear that. Because the time to discuss is over. We have postponed the current series of consultations because of a vast study in Whitehorse, which did not lead to a whole lot. And now he wants to hold another series of consultations in May. There is no reason not to act now. The same Conservatives said that they would not be taking pensions from the House of Commons, and today they're all willing to do so. And it's about time that they do something for the pensions of ordinary Canadians. So I'll share the time with my colleague from Thunder Bay.
About 3.5 minutes.
Thank you very much, Chair. And I'd first like to emphasize the words of Mr. Mulcair that things can happen quickly in government. If you think back to before Christmas, when it only took the government 4 days to pass harmonized sales tax right through the House of Commons and through the Senate for Ontario and British Columbia. Imagine 4 days. So things can happen quickly. And things do have to happen quickly, because I see every weekend when I go back to my riding, I talk to seniors who can't pay their electricity bills now. And I'm sure that you know people also who cannot pay their electricity bills or their heating bills or whatever the case may be. So we do need to act very quickly. And let me just tell you quickly about Bill C-501, which I introduced into the House yesterday. And I do thank the Liberals for indicating their support for this bill. Essentially what this bill does is it moves pensions from unsecured to secured. And that's what I've been hearing today. It doesn't move it to the top of secured, it moves it into the secured area and into preferred secured area. And so I hope that that is the first step in a number of changes that are going to be made over the years. And I certainly hope that the Conservatives and the Bloc will also be supporting this, and I'll be working very hard to make that happen. One of the things that's very clear and statistics and science tells us, and this is really for Ms. Como and Ms. Blanchard, is that the best indicator for seniors' longevity is how many friends they have. Related to that is the less money you have, the fewer friends you have. And so this is directly related to a health outcome and longevity. And I wonder if both of you, in the last minute or so that we have left here, if you would maybe have any comments on what science tells us.
Oh, Alberta, one aunt is 93 and the other is 103. I just thought you'd like to know that. And also BC, there's still people there, and 2 in Saskatchewan, my relatives, and they're older. Thank you. Oh, they're wonderful. I love going back. Thank you.
Bien entendu, à choisir.
Of course, if you have to choose between friends who appreciate us for the money we have, well, I'd rather put money in my my wallet.
Okay. What I was indicating there is that there's from a psychological point of view, there's a status thing that goes on with seniors. Well, with all people, but with seniors in particular, and money and the amount of money they have, and naturally, of course, if you have millions of dollars, you'll have lots of friends. But you could have $1 million and no friends and not live longer. So, that's yes, Ms. Como.
Well, yes, I neglected friends. Fortunately, there's quite a group with the volunteer. Don't ask me why I do all this volunteer, but until I can, why not?
Well, I wish you both all long life. So.
Okay. Thank you, Mr. Rafferty. We'll go to Mr. McKay, please.
Mr. Chair, this committee never ceases to be informative. I've been wondering for years why I have no friends. Apparently it has something to do with my size of my wallet. I wanted to go back to this conversation, Mr. Sproul, and we're having
it's because you're a Liberal.
Earlier, and that is your analogy between wages, if you will, unpaid wages or deferred wages, I guess is the better way of putting it, and that this is money that you are owed and you should have been paid and you weren't because it was put into a pension plan. Refresh my mind, what is the priority of unpaid wages in bankruptcy proceedings now?
There is, in terms of unpaid wages and contributions for existing employees to pension plans, it's the WEPA legislation, which I think was approved recently under CCAA as well, and that amounts to $3,000.
So it's a $3,000 cap.
Yeah.
My vague recollection is that if there are unpaid wages in excess of that, at a bankruptcy, that there's a director liability. Is that correct?
That's correct. And in a bankruptcy filing, you have to ask for the right to litigate against the directors. It's Section 5.1, subsection 2 of the CCA Act. And in that, you have the right to sue directors for misrepresentation, wrongful conduct, and oppression. And I believe that's where unpaid wages gets captured there.
Right. So if we analogize further to the unpaid wages situation, would you be made whole if bankruptcy proceedings that you put, if you will, the vulnerabilities about pensions in the same category as wages, assuming the cap is off, put it that way.
Yeah, I don't. It all depends on what's left in the estate, the Canadian estate. It would certainly improve our lot, and again, we don't know what the answer is going to be. But right now, we're pitted against $4 billion in bonds and $2 billion asset to the U.S. estate, and the list goes on in terms of claims on the estate. We would move ahead of that and do a lot better, but no guarantee that we'd get 100%.
Yeah, yeah. Because really, what what your ask here is to move up the scale somehow or another. Now, you're not moving up the scale to secureds. You're just moving up the scale to preferreds, effectively. Is that what it boils down to?
That's correct.
Okay. And in the process of moving up the scale to preferred, your argument is that that would not harm capital formation, and you then made the argument, well, that these companies are junk bond. But when the capital is being formed, when the capital is being invested, these companies are not at a junk bond status. They are, I mean, Nortel at one point was sort of like Mother Bell on the stock. So I go back to that question that it does seem to be counterintuitive that if in fact the whole system was changed, then there would be a potential drag on capital formation. I'd be interested again in your opinion on that.
Well, I guess the first thing I would note that 34 out of 53 countries have preferred or super priority status. And so Canada is the laggard. We're by no means going to create any offense to bond investors of the world who are accustomed to investing in those 34 countries. The second point I would make is those that are investment grade, my estimate is for those that are investment grade and that have pension fund deficits, the impact on the cost of capital, if they are not hedged with the credit default swap, is 0.16%. And that is an amount that is easily borne and should be borne when you consider the social cost which comes when these companies, through perhaps being involved, hedged with credit default swaps, who seek to enter bankruptcy for the purpose of double dipping and making profit, that they shouldn't be getting the opportunity to make a higher profit by causing seniors and the long-term disabled and survivors to take a loss.
Okay, thank you. Thank you, Mr. McKay. Monsieur Desnoyers, s'il vous plaît, pour 5 minutes.
Mr. Desnoyers? Thank you, Mr. Chair. I'm very pleased to have you here with us at Finance Committee. It's a special opportunity, and the presentation you gave for the government is interesting because for the first time they're listening to us, they're listening to you. I remember from the outset when you held demonstrations here, whether it was with the people from Atlas, Jeffries, or Nortel, and many other companies, at the time, the government said, well, this isn't a matter for us to deal with. It's a provincial matter of jurisdiction. And so they were shirking the responsibilities. And yet everyone knew that the federal government had something to do with this. And you've come today before us with recommendations, with ideas that they don't have. And I found it interesting that they could be able to listen to them and to make sure that we implement additional protective measures. You said that we need rigorous protection. When they collected your taxes for 40 years, they had a rigorous control. They went to get the money in your pockets and they made sure that things worked. And today, you need help, and there is no rigorous control. There's an urgent demand. The house is on fire. They're not sending firemen, they're sending interior decorators, and that doesn't settle the problem. Today, we need action. We need legislation, improved Bankruptcy and Insolvency Act. We need improved pension legislation. You talked about reducing taxes and benefit from reduced taxes in order to save costs. And I'm quite impressed when you talk about the social costs. Because when you lose pension income, you become poorer. you can access fewer healthcare services, or you cannot pay the things that you did in the past. And moreover, you said it wouldn't cost a cent to Canadian taxpayers. So I hope they listened carefully, because that's important to hear. And we don't need these things tomorrow. We need them yesterday. So it's an urgent ask. So I would like to hear you about the social costs. It could be Ms. Urquhart, Bernard, Mr. Saint-Michel, and about the fact that it wouldn't cost an extra penny to Canadian taxpayers. And if you want to go ahead. As for social costs, perhaps Ms. Urquhart could elaborate.
Not going to cost the government. If you do not act to amend the Bankruptcy and Insolvency Act and the CCA, it will cost the government. Because we see in the Nortel case alone that we're going to have estimated $355 million of downloading. The downloading is coming primarily from the survivors as a result of them being 60% of the working spouse's wage, and then getting a further 36% cut. This is going to put them in the range of requiring guaranteed income supplement if they do not have other savings. For the long-term disabled, they are all already on the CPP disability, but for them it's going to be a burden on the provinces because of the provinces having the prescription drug programs. And we've not spoken much about severance because this is a session on pensions, but all of the severed persons go on to the unemployment insurance plan. And so there's a heavy burden that's placed on the unemployment insurance plan when there are other more deserving unemployed, more deserving survivors perhaps, and long-term disabled who didn't have employers. And so when employers have billions of dollars, they should be obliged to honor their contractual obligations.
Monsieur Saint-Michel. Mr. Saint-Michel, what about you? Well, as for us, well, social costs. Well, if you look at a pension plan and you lose money, people say that there's no violence in that. Well, yes, there's psychological violence, and people's morale will be affected. As I explained earlier, it's the only thing that people think about. It changes their lives completely. I've seen people who have had to sell their homes. So, and there are many projects you can no longer undertake. And it's all the more upsetting that it was our money. So people can't understand. Can I simply add something? When people tell me, it's funny, people in the House of Commons, the members of the House of Commons, if it was their pension fund, they would change the legislation pretty fast. I think they're right. As for social costs, Mr. Fréchette, you should see the situation in our region. You should see how people are faring badly, how many houses have been sold, how many families are living under the poverty level, and how our suicide rate has increased. We have 300 retirees having the GIS. 300 people receive that. After 35 and 40 years of work in the mines, they receive the GIS. And the art of restructuring a company is an art. But they didn't restructure our pensions. Thank you. Good afternoon to you all. Thank you for being here. I would like to place things in context. I'm a new MP, arrived here last November. I'm also an entrepreneur. In the past 20 years, I've created jobs in my area, and I've worked extremely hard to create those jobs and to maintain them. Of course, I don't have the means as an entrepreneur and as a business owner to have an employer-funded pension plan. And I want to set that context because it's important given the questions I'm going to be asking. I sympathize with what's happening to you. And I think that Canadian society has greatly evolved in the past few years, I'd say in the past 40 years. and we have tried to implement means to secure the lives of older people. I think in general, things have gone pretty well. As an entrepreneur, I've never created jobs to close shop and to lay off workers. Entrepreneurs have a social conscience, and people on boards of directors have this social conscience, and they act in good faith when they create jobs, and they do hope to grow their businesses. Unfortunately, for all kinds of reasons, some businesses face difficulties, and there is an act to protect those companies, which is the Bankruptcy and Insolvency Act. This act tries to minimize all potential adverse effects during the shutdown of a company. And we've seen this in Quebec. This piece of legislation has had important impacts. Thanks to that legislation, it allows businesses to restructure. It breathes life back into these companies. I sincerely believe that it's very unfortunate what's happening to you. It's deplorable. And this is a question for the retirees who were affected by the income losses. If we could rewrite history, because Mr. Fréchette, you said something important earlier. You said, instead of promising things they can't give us, they should have given us what they could. And I think you can try to implement generous programs, but we have to meet the commitments, and these commitments are shared between employers and employees. I sincerely believe, and unlike one of my colleagues said earlier, I don't think businesses place themselves under the CCA or the BIA to avoid paying their retirees. Well, that's my perspective. And sincerely, when you create a business, you don't create it to dismantle it. You create it to grow it. So, I come back to what you said earlier, Mr. Fréchette. And if this was to be, if we could go back into the past, what would you suggest that we avoid this in the future? If I were a lawmaker, first of all, I can't understand how a company, because when you take your retirement after working for 40 years, and then you retire. I was retired for 7 years before seeing my pension cut, and then you meet the boss, and then he thanks you for all your years of service. And if you're not involved in that during your active years, you can't imagine that these things would happen. And I think 95% of workers don't concern themselves with these issues. It's unfortunate. It's unfortunate. In our company and in the retiree committee, and it's mostly employer-led, and these monies belong to the retirees. But those who manage these boards are the employer. And in 1991, the law changed for pension funds and required companies to create these pension boards. And we have not had 100% solvency since 1991. A company with 1,300 workers, and at the end, there were only 400 workers, more retirees than active workers. And it was at that time that they invested 75% of our money in the stock exchange and 25% in pension funds, whereas someone who was responsible would have invested 75% in our pensions. And that's why we're mad today. And that's why we say we have to defend ourselves, and we'll do so. Thank you.
Thank you, Mr. Chairman. Merci aux témoins d'être venus aujourd'hui.
Thank you to the witnesses for coming today. I have a few questions. the witnesses. Now, if we want to do something today, what could we do for you, Mr. Fréchette, and for you, Mr. Saint-Michel, and for you, Ms. Blanchard? Now, because changing the Bankruptcy and Insolvency Act will not help you all that much. I'll start. Well, if the legislation was amended to say that pension plans are should be preferred creditors, it wouldn't concern us, but at least we would be exceptions, and that's where it's important. I know that there's a bill that's coming up, Bill 290, and that bill recognizes the losses that we incurred. If the legislation were to be amended, and some say it will be very costly, and others say the cost will be minimal, but if we were to change the legislation and pension funds were considered as preferred creditor status, Bill C-290 could settle a lot of problems, and I don't know when third reading of that bill will come up. I think with such legislation, we could find a certain stability. So you worked for Atlas Steel. It no longer exists. When did it go bankrupt? Well, in fact, it didn't go bankrupt. They simply liquidated all the assets. And when we left, there were always actuarial assessments of over 100%, so we weren't concerned. But when the company faced difficulties, then all those who could act didn't. And no amounts were contributed to the pension plans, and so we ended up losing, because there were 3 pension plans, we lost between 30 and 58%. And each year that I worked there, and there was an actuarial evaluation, they didn't note any problems. We even had a solvency ratio of up to 120%. But when an employer faces difficulties, to respond to a question I was asked earlier, and they don't contribute as they should in a pension plan, well, it's a grant that is awarded to the employer, and that's inconceivable. That's exactly what we went through, the retirees of Atlas Steel.
If there was a change right now to the Bankruptcy Insolvency Act, would that help you at all with the Nortel situation?
Yes, we would believe. I mean, Nortel's under CCAA right now, but they haven't moved under the Bankruptcy Act.
And that's only going to happen in the month of September, correct?
And we don't know when it's going to happen, quite frankly. Okay. There's no date set. Could I also, I'd like Madame Urquhart just to respond to something that was said earlier. I'm stealing from your time. I'm sorry.
So that's why I'd rather just wait, because my follow-up question is on the disability side, and perhaps, Diane, you can answer that as well. Why are the disabilities? Is it because it's long-term that they're not being managed by an insurance company? Why is the money still in a separate fund or unfunded? I mean, when you look at even for parliamentarians, our fund is administered by outside sources, whether it be Sun Life or...
Yeah, the problem has arisen because there is a substantial number of corporations who self-insure their long-term disability benefits. What that means is that they are acting in the role of an insurance company.
But doesn't somebody agree to that?
What happened in the Nortel case is that it was misrepresented. Up until 2005, there were no disclosures that would lead anyone to believe that they had a long-term benefit that was not insured by a third party. Post-2005, remember this is a non-unionized environment. Post-2005, they indicated that it was self-insured for the first time, but they said they were playing the role similar to an insurance company. However, they were not playing a role similar to insurance companies. Since 2004, there were no employer contributions made into the health.
Nobody at Nortel and the staff or on the union side would have.
Well, apparently not, because all of the 400 LTD were shocked when they saw that there was $100 million missing from the Health and Welfare Trust, which they learned for the first time on February 18th.
Last question.
So how is that going to be avoided in the future if a company does decide to self-insure?
I think if you make the Bankruptcy and Insolvency Act, which we'd like you to do on an urgent basis, and we'd also like the long-term disabled to be put ahead of all the other employee groups. Because
it wouldn't matter if it was self-insured or not?
Then it wouldn't matter. Whether you had a health and welfare trust, whether you had a trust account at all, whether you had a trustee agreement, it would be irrelevant. And it, in fact, would be a very good way to provide long-term disability benefits on a self-insured basis, because you only have to come up with the goods at the time of the bankruptcy.
Okay. Thank you, Mr. Pichetti. We'll go to Mr. Menzies, please.
Thank you, Mr. Chair, and thank you to all our witnesses for coming here today. And I appreciate how difficult it is to talk about your own personal circumstances. So we do appreciate this. And I mean, as much as the opposition is criticizing us for consulting, that's exactly what we're doing today. And we've, I've met with Donald Sproul on a couple of different occasions, and Diane Urquhart, and I mean, this is what we need to do, is to hear from you folks. I mean, I'm learning more things again today, and I've been dealing with pensions for 2 years now, hearing from people all across the country. So, I mean, for them to suggest that we make a decision right now, what's that decision? How's that decision going to impact future pensions? Well, Mr. Payee, if you want to talk back, I invited you to my office and said, have you got a comment? Can you contribute to this conversation? I'm still waiting for an answer. So if you'd show a little respect, if you've got an answer, let's talk about it later on. Otherwise, this is my opportunity to ask some questions. All of the individuals here today, at one point, were under provincial jurisdiction, and I think that's something that isn't understood, and I think, Diane, you understand that, and Dawn, of course. What Mr. Saint-Michel just said is very troubling, and what happened to you is wrong, absolutely wrong, and that sort of thing shouldn't happen. But there's provincial jurisdiction, there's federal jurisdiction. I think there's a lot of uncertainty when it gets into bankruptcy. A bankruptcy situation, it is federal responsibility. And we've said that we're looking at it. The Minister of Industry is responsible for that, and he is seriously taking a look at it. This, believe me, the Department of Industry Department is watching these hearings and listening to what you're saying. So we do appreciate your comments. But there's been some comments, and Ms. Urquhart, you've provided us over a number of appearances with some good statistics and some good comments. But I'm concerned about the comments about this guaranteed fund, pension guarantee fund, and I'll just from a previous appearance we had Edward Whitehouse speaking to us. Now, Edward Whitehouse is with the OECD, a pension expert, and when John McCallum asked him about that, how good these pension guarantee funds are, his comment was, I'm afraid to say that I do not think there is a good international example of one of these types of insurance funds. He goes on to make other comments about it, about the US and the UK. They're not effective. We want to find something that's effective. We saw what happened in Ontario. There was supposed to be one there. It's gone. Have you got suggestions how we can build one better than all the other OECD countries have failed with theirs? How do we build? Is that where we want to go? Give us some insight,
I guess my perspective is that I would rather that you spend your time on providing preferred status for the pensioners and the terminated workers, and that you give us a preferred plus or super priority for the long-term disabled. In that manner, we can be assured that when there is money in the corporations, that the monies are going to fulfill the commitments of the deferred wage and to fulfill the insurance-like product that they offered employees. I personally am not a big fan of public insurance guarantee plans, because I'm concerned that it does give the opportunity for an offloading of legacy costs that were committed by the corporation. And if they had funds to honor those obligations, that those funds should be used first. And so I don't like to see the opportunity to take thousands of people and put them onto a public insurance plan, which is then borne by all corporations.
Well, and the concern and this is a personal view, the concern I have, if there's a pension benefit fund there, a guarantee fund, then it takes the onus away from a sponsor to even live up to his or her promise.
I agree with you.
I'm certainly not an expert in this area, but I know there are proposals around that would actually stop some of the downloading that happens in corporations to the public insurance funds. But when I went in front of the Finance Committee in the Ontario Legislature talking about the Ontario Fund, I said, could you please connect the dots? Yes, the fund is underfunded right now, but if they had priority ranking in terms of bankruptcy, then the Ontario government recoveries and payouts for that pension benefit guarantee fund would be reduced. So again, I think it's not an either or. I do believe that number one is changing the bankruptcy laws, and that would actually allow Ontario, had an expert commission that said, let's increase the payout of that pension benefit guarantee fund. And if you get changes to the bankruptcy laws, I think that would have a very good feedback loop.
Thank you. Thank you, Mr. Menzies. We'll go to Ms. Hall-Finley, please.
Thank you, Mr. Chair. And thank you, everybody, for being here. Ms. Como, I actually wanted to ask you, and a personal thank you for being here, because obviously you're having, you know, it takes something to come here and to participate in this, so much appreciated. Can you explain to me, and you'll just have to bear with my ignorance of this, can you explain to me a little bit how it worked with what your husband needed to do, what he did with regard to his pension to allow for you to have a survivor pension, and how, just if you can explain a little bit how that worked.
Thank you for asking. When my husband was time to retire, he opted for a reduced pension. I believe it was 10%, so that if something happened, and of course that was the case, that I would receive a pension. Now, naturally, as a senior, old age pension out to Quebec I have, but this survivor pension makes all the difference in the world. Now, of course, when I received the pension, he had 10% off of his full pension. That was what we started with, all right? When he passed away, I received 60% of the pension he was receiving at the time of his passing. Now we're talking about an extra 30%. And this is a lot. Think about it. 10, and then 40% more off, and then now 30, over 30, I believe.
So let me get this straight. He agreed to take 10% less.
Yes.
That from what he was going to get.
That's right.
But that you would only, in fact, get at that. So in each year, then he got 10% less. You were then able to receive 60% of that 10% amount.
Well, let's say 90%. He received 90% of his full pension.
Right.
90. When he passed away, I received 60% of that 90.
Oh, 60% of the 90.
Which would be what? 54, 54, si je me trompe pas?
54.
Is that right?
Yeah.
Right.
Yeah.
And then now another 30 plus.
I think to also consider that his pension, which was 90%, was 60%.
Pardon me?
People don't retire at their working wage. So they get 60% of their working wage. Then he takes 90 of 60, so now he's 54. Then she takes 60% of 54. So who can do the math here? 35. And then take another cut of a third.
But that survivor pension, absent the challenges of Nortel, that would have stayed with you until for the rest of your life.
Yes, it was. Yes, definitely. It's difficult. What can I tell you? It's nice to see that there is from different provinces here, so I can not just say Quebec help me. I hope the others do too.
Well, and I will venture, Ms. Como, that notwithstanding the effort or some of the challenges back and forth, that all of us from all parties are very actively engaged and interested in this consultation process. So I want to thank you all.
Thank you.
Mr. Frechette wanted to comment. Ms. Hall-Finley. Monsieur Frechette.
Il y a même une loi sur les pensions.
There's even a private pension act in Quebec whereby when you have your pension and you the spouse has to sign if does not want to receive a survivor pension, and so we've had that legislation for the past 4 or 5 years.
Thank you, Mr. Chair, and I want to thank each and every one of you for coming. I only have a couple of questions, and then I'm going to pass it back to the chair for the chair to ask a few questions. First of all, Mr. Chair, I really appreciate the presentation you gave today and the numbers that are here. And I understand you're going to be providing the actual study that you provided to your, I don't know if they're clients or how it works. Do you mind if we have that peer reviewed? Because numbers can lie and be maneuvered, and so to confirm the number of the social services piece, I would feel more comfortable if I got that peer reviewed. Do you have any issue with that?
Sure, and in fact, work in the public.
Yeah,
so
don't touch the button.
It's been broad. Thank you. It's been broadly circulated with invitations to anyone who would like to make suggestions as to where I may not have it right. And so far, no one has produced any contrary studies, but you're more than welcome to send it anywhere in the world.
Okay, thank you. One question, just for clarification for my own. We're hearing about September and a reduction of 30% and so on. Has your pension been reduced? Your income pension, monthly check, whatever it is, been reduced as of yet?
No, it hasn't. The basic pension plan, there are other plans that people have had reductions, but for the majority of people,
So are you assuming that it's happening, or have you been notified? That
no, we've been notified.
Okay, yeah. Just one clarification.
In fact, we've been under negotiation with the corporation to stretch that out.
Okay.
To give us some time.
Okay. Pass it back to you, Mr. Chair.
Thank you very much, Mr. Wallace. I wanted to follow up on some of the questions from Mr. Pichetti. Madame Ricard, you were talking about Nortel was not actually forthright. If I understand you correctly, they were not being forthright with respect to their long-term disability plan, because my understanding is the same as Mr. Pichetti's, is in normal cases it's a third party, it's Sun Life or whoever that would manage this, so it's not in fact a troublesome thing as this happens in this situation. So can I just make sure I'm understanding correctly that the company in this case was in fact not forthright with respect to their long-term disability plan?
They were not forthright with respect to two matters. They did not adequately advise the employees of Nortel that when they made their own employee contributions to raise the amount paid, or when the employer made his own contributions, that those contributions of money were not going to a third-party insurance company. Post-2005, they said they did admit and give qualifications that this is self-insured, but they would play the role of an insurance company. The other wrongdoing was that in playing the role of wrongdoing, there was a trustee agreement that required employer contributions to be put in each year to fund the present and the future long-term disability wage loss replacement claims and medicine claims. And those employer contributions have not been made for many years.
Now, in terms of, you talk obviously about both moving up the pensioners, but you talk about the long-term disability in terms of moving it up in terms of the priority status with the BIA. But do you also then have to amend, whether it's BIA or another act, to ensure that there is accountability and transparency between a company and their employees, as did not happen in this case?
Well, we'd like to see the BIA amended because it's going to deal with all circumstances now and forever, whether or not you have a trust account, a trustee agreement, whether or not you're simply providing those long-term disability benefits on a self-insured basis. So we'd like to take this first step with the BIA amendment. It would, however, also make sense to proceed to make other amendments, such as the Federal Corporations Act, such as the Federal Labor Act, such as all the provincial acts. But I would like to encourage the Conservative government not to wait because of the ratification of the UN Convention on the rights for persons with disabilities. It says every actor in the network of actors who is working with the disabled do what it can to ensure that the rights of the disabled are protected. And so I'd like to see the federal government move with the BIA. I'm of the view that it should go now, it should go first, it should go in any case, and we shouldn't wait for the provinces to make the further amendments that should be done to repair this problem once and for all.
Okay, thank you. I had more questions, but my time is up, and I enforce it on others, so I'll enforce on myself. We'll finish Mr. Rafferty for the final round, please.
Thank you, Mr. Chair. And I know everyone's going to run out and get a look at C501 to see what I tabled yesterday. I'll just give you the summary quickly here. This enactment amends the Bankruptcy and Insolvency Act and the Companies Creditors Arrangement Act, to ensure that unfunded pension plan liabilities are accorded the status of secure debts in the event of bankruptcy proceedings. The enactment also amends the Canada Business Corporations Act to provide an efficacious procedure by which former employees of a bankrupt corporation who are owed amounts by the corporation can proceed with claims against its directors. That's the summary of C501. I hope everyone has a look. Ms. Urquhart, I thank you for talking about the cost. And the cost of not acting, which you talked about a little bit before. And one of the reasons I brought this bill forward, which is a reworked bill from Wayne Marston, Hamilton, Stony Creek East, and I think is a bill that's going to be acceptable to all parties once they have a look at it, is because tens of thousands of forestry workers in my riding in Northern Ontario and tens of thousands more forestry workers right across this country and manufacturing workers did not receive any severance, did not receive any of their pension or their deferred wages, which is going to be a question in a second. And now what is happening, many of those, the employment insurance is running out, and they'll soon be on the welfare roll. So if you want to talk about the cost of not acting, that's one of the costs. I do have a question for Mr. Samichado. One of the things you said earlier, and this is my translation. I hope it's right here. The employer told you that a pension is a part of your salary that we don't give you right away. And I wonder. I call that deferred wages. I think you called it foregone wages. I wonder if you'd like to make a few more comments on that in the small time we have left.
Well, perhaps I wasn't clear, but what I wanted to say was that it's deferred wage. It's whether you have the wage now or later. During the years we worked, we didn't have a choice. The pension plan was there, and we had to contribute to it. So we were told that part of your wage is deducted. However, when you retire, you'll have a pension income, guaranteed. Well, we see the results now. And for the past 5 years, between 30 and 58% of our pension income, depending on the pension regime, which have gone missing. So these are sizable amounts, and we have to deal with them.
Around this table, and I think they do now, is that deferred wages are owed to the workers. They earned that money. And I think that's an important principle to understand. And I think that. Oh, sorry, pardon me?
Mr. Frechette would also.
Oh, Mr. Frechette, pardon me. Go ahead.
Thank you, Mr. Chair. All I want to say is thank you, first of all. And I would take the opportunity to say that I'd like to thank you and say that the CCAA, had it been there in our time, it would have been very, very beneficial to us. And I do hope that it's amended for people from Nortel. But for us, it's of no great help anymore. We're in the same situation as they are. But if the CCAA were to be changed, when I heard the Conservatives on TV talk about billions and the billions it could cost, if the CCAA were changed, it would be reduced costs, actually. And what I want to say is that we've worked some time. We are these young fellows who have worked all our lives in the mines. We've done our best, and we do hope that we shed some light on this, and that you'll be thinking about us when time comes to drop legislation.
Seconds left. If Ms. Urquhart could make one last comment.
I just want to make the comment that we're very concerned about the Nortel Canada estate. Nortel's bankruptcy process is being driven out of New York by the Unsecured Creditors Committee. It's entirely possible that the Canadian estate will not have significant funds in it. My estimates are approximately $1 billion out of the $6 billion could end here. As you can see, there's $1.1 billion just in the pension fund alone, not including the medical costs. And so that's why I've come today to make sure that you're aware that the long-term disabled who have only 17% funding in their health and welfare trust, if they're pari passu with the pensioners, they are going to end up going to the poverty line. And so that's the basis upon which we say in the Nortel case and in the general case that the long-term disabled need to have a preferred plus status. And there will not be enough money likely in the Canadian estate to pay all of the pensioners and the terminated workers and the long-term disabled. And if the long-term disabled need to take an average of the small amount that could come to the Canadian estate, these people will all go to the poverty line. And so it's on that basis we're asking them to be lifted one notch higher. And it's because of the health and welfare trusts that are not funded, not regulated relative to the pension funds, that as a matter of policy and because of their illnesses and peace of mind that they need to be slightly higher.
Okay, thank you. Thank you very much, Mr. Rafferty. Merci beaucoup pour vos présentations. Thank you very much
for your presentations.
Colleagues, we just have one small item of business, which is the budget operational request, which is for witness expenses. Moved by Mr. Wallace.
These witnesses, right?
That's correct. Yeah. These and all witnesses with respect to the pension study. All in favor? Thank you. Thank you. That's approved. Thank you very much for being with us. Meeting adjourned.